talking about, we're going to talk about fair housing. If you guys didn't know that September, oh my goodness, April is Fair Housing Month. And we're going to just go basically over a couple of things that I think agents need to know. And then we're going to go over some changes in Louisville. And then there's also some additional things that if you are in the real estate industry as a listing agent or a buying agent, things that you need to look out for that are becoming a little bit more commonplace now, especially in this crazy, crazy market. And we just don't want anybody stepping on any landmines and doing things unintentionally that could, you know, just raise some red flags. The way we're going to do this is I'm going to basically go through the presentation. If you have a question, I'm going to answer the questions on the Zoom call. I am live on Facebook right now. I've posted the link in the bottom of this. And if you want to link onto the Zoom call, that's where I'm going to answer the questions, and just do them with the question and answer portion. I will not probably do those until the end, just because some of the questions may be answered throughout the thing. And there's a lot of information. Okay. So for those of you guys who don't know, I'm Colleen English Balderson, partner at the English Law Group, and we do real estate closings, wills, that kind of stuff in Kentucky and Indiana. So I am an attorney licensed in Kentucky and Indiana. And if you ever have questions about this or anything else pertaining to real estate or estate planning, that kind of thing, please let me know. And I'm also always looking for people that we work with to help present some of this stuff, because sometimes you don't want to just listen to me. Maybe that's all the time. I don't know, but you're on the call, so I would assume you're good to go there. Okay, so basically, there is federal law, federal fair housing law, and that is a very broad umbrella of what, there's a very broad umbrella of what that covers. And basically it deals with anything that is residential real estate for lease, for rent, well, it's the same thing, for you know, anything doing with housing, buying, selling, all of those things. If it has anything to do with those things, then the federal fair housing, it covers that. You then get down to the state level, and there's other overlays on top of that where states may require even additional protections. And then there is metro or even smaller city levels where there could be additional protections. So we're going to talk about Louisville has actually added some classes to those protected classes that you can't discriminate against. So we're going to talk about that in depth. Some of it's a little confusing, and with any time there's a change in the law, it takes some time to figure out exactly how that's going to be implemented and what that really means and how some things are defined. So just be aware of that. The federal fair housing is, there's tons of case law on it. There's been a lot of litigation, and luckily some of these classes, there's been additional classes added to protect people that need protection. So I will say that when I talk about protected classes, that's kind of a constitutional law term. And basically it means any class of people that are protected by these laws. So there can be all kinds of different, protected classes. But when we're talking about fair housing, we are talking about, and I'm just going to read it so I don't leave anybody out. Federally, it is race, color, religion, national origin, sex, handicap, and familial status. So you cannot discriminate against somebody who has little kids. You can't discriminate against an elderly couple moving into an apartment. You can't discriminate, on race or nationality. And a protected class is not somebody that speaks a certain language. However, it would be easy to probably put that in a category of national origin. So be aware of that. I've had people say, well, if I can't communicate with them, then I don't want to rent to them. Be very, very careful with that, because you could be saying that you are discriminating against somebody's national origin. What language you speak is not necessarily a protected class. If you say that you don't want to rent to somebody with a lizard or something, that's not a protected class. People that, you're not going to the thing is that when you're talking about protected classes, there are certain ways that it's like, well, okay, you're saying that, but do you really mean this? but just know that those things are on the lookout. And I think that as a society, we are getting more and more litigious on this kind of stuff. And there's more and more ways that you can violate these things and violate them unintentionally, I think, for the most part. Obviously, blatant discrimination is going to be pretty easy to point out, but it's some of these subtleties that make it a little bit harder. So you can't discriminate against any of these classes. Now, I've heard in different real estate classes I've been to that people say, you can't say, well, and this was actually on the news last year, you can't say mother-in-law suite. Technically, you can. There are a list, and actually GLAR has a great handout. Most of my stuff came from it, that they sent out last week, I think, or maybe at the first of the month, with a bunch of different places where you can learn about fair housing. And, instead of saying, what you want to do is when you're doing an advertisement or you're putting a listing up, you want to focus more on the property than the person that's going to buy it. So you may say minutes from a jogging loop. That's fine. It really is. But you don't want to say great for joggers, because then somebody may think, well, you're talking about people that are in wheelchairs can't jog, so it's not great for us. And maybe you'll discriminate against us. So keep that in mind. Always focus on the actual property, not on the person who will be buying it. If you say, minutes from a park, legit. Okay, look, it sure is minutes from a park. But if you say great for families, minutes from a playground, or you're not supposed to talk about schools, because then it's really geared towards a certain family type. And you cannot discriminate. There are exceptions for properties where elderly people over the age of, and I don't think it's elderly, but over the age of 55, and it has to be 80% occupied by people over the age of 55. It's a very, very carved out rule. And so if you are trying to show somebody a condo and they're like, we don't accept people over the age of 55, that could be legit. So just make sure. But if they've also gone over capacity and they're at 70%, then at that point, they no longer qualify for that. And they have to open it up to everyone. So, that is really the main nuance when it comes to familial status, is for those communities where people are a certain age, which is usually over 55. If it's a condo association, and let's say you have some units that are, the playground over here is for the kids and over here it's for these people, you can't really do that either. Because unless you're qualified as one of those communities, you can't earmark certain places for different types of people. And so that's really important to know, I think, because I have had people say, they're saying that my clients can't buy this. I don't understand. And that is a nuance. That's a carved out rule. Let's see. All right. So you want to, if you want to send me an email, and I'm going to take a picture of everybody who's on here, or just email me at Colleen@EnglishLawGroup.com. And I can send you a copy of the Fair Housing logo. I would put it on your websites, and any brokerages should really have that in the lobby. It's just kind of goes along with saying that, hey, we're going to do everything we can to make sure we're not discriminating. And why not? I mean, that would be a really good thing to put out there. We're going to just do a little examples of this is okay, this isn't okay. All right, some of this stuff's pretty obvious, but I think it's important. Regarding race, color, and national origin, you can't say that words that describe the housing or potential residents in racial or ethnic terms. Now, there was a case law about an apartment complex, and it was mainly Korean people, and they wanted to keep it Korean because the landlord was Korean. You can't do that. You have to, if you have signs in Korean, you also have to sign, signs in other languages as well. And so you can't discriminate, even if it's the protected class that you're trying to protect, you can't discriminate against others. So there have been cases where, the protected class, you may think a minority, but it turns out that they were discriminating against, white Caucasians or something like that. You can't do that. You can't differentiate anybody by those standards. Okay, so for religion, you can't say no Catholics, no Christians, no Muslims, but you can. You also can't use ads using the legal name of an entity. So, St. Margaret Mary Catholic Church, great, school is, whatever. You can't do that. But you can, and this is one of those things that's kind of, different. You can send out emails saying Happy Easter, or you can send out Christmas cards or put on your Facebook page, Merry Christmas. That's been determined that is acceptable, but technically it's an ad, you're at it, and you're putting forth, I would just do it for every occasion, Happy Hanukkah, different things like that. But that is acceptable. That's been deemed acceptable. For sex, it's unacceptable to have a general or a gender preference. So you can't say females only, males only. If it is a shared, if it's a community aspect, like you're renting an apartment and there's going to be more than, you're going to be using common space. In that instance, you can say females only or males only. But if it's standalone apartment or a house you're selling or something like that, you cannot make it that this building is females only. Dorms can do that, but you can't as a landlord. Let's see. You can use the term mother-in-law suite, and you can use the term bachelor's apartment. Now, there was a whole thing last year, I remember reading it, that said that mother-in-law suite's going to be, not acceptable, or master bedroom or something like that. So far, I don't think that there's been any case law determining that is not a good thing to do. If there's another way to describe it, just to be safe, maybe you should do that. But I think for the overall, this is written by NAR, talking about what's acceptable, and they have as an example of something acceptable to be mother-in-law suites. Handicap, you can't say that no wheelchairs, that's not okay. If you're saying it because there's steps, then what a landlord would have to do is, and this is a whole other sector of this program, but the landlord has to let the tenant make reasonable accommodations in the tenant's own money to do it, and they have to be able to return it back to the normal state. So if it's unreasonable, they got to knock walls down, they have to do this, that, and the other, then the landlord doesn't have to let them do that. But if they want to put a ramp to go into the property, they can. If they want to put the handbars in a shower, they can do that. They just have to be able to return it back to the original state. And if it's something that's an extraordinary expense, like let's say they're going to take out it's an old house or something, and usually those doors are bigger, but let's say it's a small little door, they got to open it up so that a wheelchair can get in and out of a bedroom. If it's going to be something that's more expensive and maybe structurally something like that, the landlord is allowed to create an escrow account to pay for what it's going to cost to replace that once the tenants move out. They can't say we need $10,000 right now. They can say what we're going to do is we're going to collect, $75 a month until, this has been met. And basically it doesn't go towards your rent. It is just for this. If it's going to be a ramp that would be pretty easy to take out, you're really not supposed to be collecting those escrow checks or creating an escrow account for that. All right, let's see. Familial status, which just is family status, is ads that limit the number or ages of children. So you can't say minimum 2 kids. Now, what you can do is you can say that we have a capacity limit. That's completely reasonable, and that's almost a fire thing. And it has been determined, not a steadfast rule, but it has been determined that 2 people per bedroom is the acceptable number. However, there's always a however. You could also say that somebody's going to sleep on a couch, or depending upon the makeup of the unit, maybe there's going to be a pull-out couch and they're going to have, their 10-year-old sleep there or something. But for safety reasons, you can limit, but just be, it has to be across the board. It can't be, okay, in this place we have this, but these people have a 2-year-old that's going to be pounding on the ceilings and, whatever, knocking stuff over. So we don't want 2-year-olds, but we'll take kids 7 years old or older, which actually they're louder. I've got a 10-year-old and he can make some noise. But anyway, so you can't do that. You can't say what age group. I have had a landlord one time give me a call because the people were moving in, they were basically at capacity and she was pregnant. So that's really tricky because there's going to be another baby. And I think you just kind of need to, address those situations as they come, but you need to have kind of a steadfast rule of what's going to happen. And I would really talk with an attorney about that situation and what logistically really, a baby doesn't take up that much room, but if you're already at the capacity and it's like really tight, maybe letting them know, looks like you're going to have a baby, just to let you know the maximum capacity for this apartment is this number. What are you going to do then? Maybe they're going to give the baby up for adoption. I mean, I don't know. You don't want to get too much into that kind of stuff, but letting them know in a very professional way, these are our standards for the number of occupants. Is that going to be an issue? And then, whatever they say without getting too much into their personal details. All right. So also, if you are advertising, you should mix it up with who you show in your advertising. There's a use of models section of this document. Basically, it says that if you're going to use human models to show a house, you can't always use, people, I guess, walking white family or something. You have to have different ethnicities. Maybe you should show somebody in a wheelchair. Anything that you can do to show, yes, we are open to new things. Now, every ad that you have does not have to have, a plethora of different models, but don't keep using the same people, I guess, in your ads. Or if you are, if you work with a lot of people who are Spanish speaking, you have to mix up where you advertise. You can't just put things in the Spanish, like the little newsletters or whatever that you get in Kroger's or something. You have to diversify as far as where you advertise. Now you could put Spanish stuff out in something else, but you can't only advertise in a place that you could say, oh, we are preferring that we work with people of this national origin. So that was kind of news to me. I did not know that. So, really and that's that's under the federal umbrella where they say diversify in where you're advertising. All right. Let's see. If you are somebody that works primarily with people who are downsizing and retiring, and there's designations for that, that's fine, but you can't make it seem that those are the only people that you work with. So if you're like, oh, I don't want to deal with kids, showing kids all around these houses, you can't do that. You can't say, I only work with listings for people who are going in retirement facilities. I mean, I don't know why anybody would want to pigeonhole themselves on that, but you can advertise that you have this designation, but just don't make it seem like those are the only people that you work with. All right, so you cannot discriminate under the handicap standards. You can't discriminate, obviously blind, deaf, wheelchairs, that kind of stuff. But alcoholics, people with AIDS or HIV, you cannot discriminate against any of those people. Now, you do not need to rent, and we'll even go in this when we get into the Louisville stuff. You don't have to rent to somebody who is a known drug user or a known substance abuser. So if the alcoholic's not in recovery and you know full well that's the case, then you don't have to do that. And basically they look at what would pose a direct threat to the health and safety of other individuals or those that would result in substantial damage to the property of others. So if you have someone who you're like, gosh, they're gonna, just use your best judgment. Okay. Then, let's see, we already talked about the modifications. So some of the examples that they give are grab bars in bathtubs, on toilet seats, widening of the doors to permit the usage of or the passage of a wheelchair, installation of flashing light in lieu of a doorbell, and relocation of environmental controls. So again, it needs to be reasonable. Lawyers love the term reasonable. So would the normal person think that this is a reasonable accommodation? If you are going to have to put in an elevator into a 2-story house, those are usually about $15,000. So at least, so that's not probably going to be considered reasonable. If you have to put a ramp up to, to get a wheelchair up the stairs, and if that's a possibility, maybe that would be reasonable because it's substantially cheaper. But again, that's where that escrow account could come into play. And it might be that if they know that they have to pay to get it back to what it was before, because I mean, it's $15,000 just to install the elevator usually, then like 10 to 15, then to take it out would probably be thousands of dollars in addition to that. So, I think that would be extraordinary, an extraordinary expense. Let's see, homeowners associations. So if you represent a homeowners association, you have to allow owners, if there's a clubhouse or something. If it was, I think it was before 1988, if it was built before then, it may not meet the standard requirements for handicap accessibility. You would have to allow that person within the association to make whatever they needed to in order to make it handicap accessible. So if that's tearing down a bathroom and building one that's handicap accessible, that might be extraordinary. But, maybe as a whole, you would want to look at that and say, okay, do we want to do this? Because it's probably pretty important that people can get in there. All right, so you have to allow, and this is where it's going to get really tricky. You have to, if you have like a no pet policy and you're a landlord, that's fine. But if there's a seeing eye dog, you have to let them have a seeing eye dog. And again, that would be reasonableness. Maybe you still have them do a pet deposit because it's still an animal and it doesn't matter what kind of an animal. But there's a lot of people that have therapy animals now. And where's that going to cut off? I don't know. There's no case law on that out right now. I don't know. I mean, if it's an enormous dog that's their, therapy dog for anxiety or something, I don't know. Maybe you draw the line there, or, because you don't have to, you can discriminate against types of animals. They're not a protected class, but you can't discriminate against the person. So just really be careful when you do that, because more and more people are getting these animals. And so I think that this is going to become a bigger thing, but there's no case law out on that yet, at least that I could find. So if you know of any where there has been a ruling saying you have to allow the cat that's the therapy cat, let me know. I would love to have that information. Or if you guys have anything that's contrary to what I'm saying, please let me know that as well, because I don't want to be relaying the wrong information. And I am not a constitutional law attorney, but this does go over real estate, and I certainly am a real estate attorney. So, all right. So anything that's been built or modified, in the last, since all these rules came out, they're going to have to meet the standards. If you have a house and you're taking the bathroom out and it's going to be, something you probably want to think about, I think anymore, in order to get a permit, it's got to meet these standards. So, and I will say also, if it is an owner occupied dwelling, so let's say that it's a fourplex and you own one of the fourplexes, some of these rules don't apply, because they think, okay, if you're going to be living there, then, there's different rules. So just make sure that you find out which ones do and which ones don't. Okay, so someone just said that the standards only apply, hold on, when considering accessibility items. Okay. Also with no Section 8, we're going to talk about that in a second. And no smokers, I would say that you can say no smoking in the premises, but it does not say anything about smokers. If you say that this is a no smoking building, it can be a no smoking building. I don't know that you can say no smokers, because then someone could argue, well, that's an addiction. And if you're, so you can definitely say no smoking, but no smokers, I don't know. I don't think smokers are a protected class, but they could probably argue that it's a disability of some sort, and maybe some judge would find that that's the case. So again, I would just say no smoking in in your rentals or whatever. And as far as the accessibility for making the modifications, it is in fourplexes or higher. So thank you, Will, for pointing that out. If you can make it accessible and you're going to be renting it, you might be open to a lot more tenants if you do all the accessibility things with the permits. And I know that like the doors, you want to be able to always have a wheelchair go through the door. Okay, so let's see. Let's see. Okay, so I want to talk now about Louisville. And so if you have anything about the federal laws, we can talk about that when we do the questions. But as far as Louisville, this actually went, Indiana tried to adopt some of these things and it didn't go through. So in Louisville, Jefferson County, not in Oldham, not in Bullitt, not in any of the surrounding counties, but just in Jefferson for now, there have been additional protected classes put on the list, okay? One of them is veterans. So you cannot discriminate against a veteran. You can't say no veterans, or if somebody's filling out their application, prior employment, something in the military, you can't just be like, no, we're not going to do that because I don't rent to vets, or we won't accept applications for a house, in this market. I'm not going to do a VA loan. Well, you can discriminate for the loan type, but you can't discriminate for the person. So you can't say no veterans. But as a member of the board of VA rep, it's really important that people who are going to say no VA loans, that they understand that there's a lot of misconceptions about the VA loan. So I'm just going to put a little plug out there for that. If you're telling your clients don't accept any offers for VA loans, you might not have the most, you might not have, some of the information. So be really careful when you're doing that. Not to say though that you can't say certain types of loans. So anyway, sidebar. Okay, but you cannot discriminate against veterans. And you cannot, let's see, you cannot discriminate against how somebody gets their income. So you can't say we need like the source of income. So if they get source of income from a government agency, you can't say we're not gonna put your Social Security into this equation. I believe that was put in there to try to broaden Section 8. So if you are getting your rent from Section 8, you can't say we don't accept Section 8 vouchers. Okay. However, you could probably put in there for now, because it doesn't say anything about the modification of the house and making sure that the modification of an apartment or something meets the Section 8 guidelines, because they're strict. Section 8 is super, super strict. So you might be able to say, we'll accept any type of income. However, we will only make reasonable repairs to the property. Now you don't want to look like a slum landlord or anything, but at the same time, if Section 8 is going to come in and they're going to be like, okay, this light switch, this is cracked, this, and we'll be back in 3 weeks to look at it. And then they come back and they look at it again. Some people that do Section 8 absolutely love it. It's a guaranteed payment. But some of them are like, oh my gosh, they're going to have to, like with the property that we have right now, they will have to redo basically everything. So I think if you put in there reasonable accommodations, and repairs, you could probably, work within that. It might be that they change the law to say that every landlord has to accept Section 8. I don't know. I don't know that you have to accept the vouchers, but maybe not the property conditions. There's nothing there is nothing that has been said about mandating that people modify their properties to meet Section 8 guidelines. So I will put that out there, nothing. So, but that might be the direction we're going, but it hasn't been done yet. We also, criminal activities. So let's see, I'm gonna look up real quick. Hold on just a second. Okay, so criminal activities. This is where it's really, I think it's pretty confusing. You have to see, so if you are a landlord that does a criminal background check, there are only certain things that you can say are deal breakers as to whether or not you'll rent to someone. You cannot put arrests into that. So if the person's been arrested 15 times but never convicted, it has to be a conviction, okay? Let's see. Okay. Basically, okay, you don't have to, again, you don't have to rent to a current drug user. If somebody has been sick, if somebody has been kicked out of government housing or evicted from government housing because of some sort of criminal conviction for 3 years, you cannot rent to them. Now, if that was 5 years ago, you know, if it doesn't fall under one of the other categories that I'm going to say right now, you may have to rent to them. You may not, or you may not have to rent. You can't discriminate based on that. Okay. And usually with those things, it's a drug related crime. So, you know, you get a 3-year window there. If they're a known drug user, if they show up and you're like, wow, this person is on something, it's tricky because maybe it could be a mental illness, you know, I mean, who knows? Like, who knows? Unless they say, yes, I'm on drugs right now. I think that's kind of a tricky layer there. If the conviction had to do with a violent crime, a capital offense, a Class A felony, a Class B felony involving death of a victim or serious injury to the victim, anyone who has killed or attempted to kill a first responder, if they have been arrested relating to meth production, or a registered sex offender, or if they've ever had anything to do with human trafficking. So, you know, meth, human trafficking, sex offender, those are kind of easy. I'm not a criminal attorney. I don't know what constitutes Class A felonies versus Class B felonies. So in that instance, if there's something that is one of those things, you probably are going to have to talk to a criminal attorney and say, hey, does this fall underneath there? Or you could call up, you know, Louisville Metro Housing Authority, and they might be able to better define that. But I mean, I don't know what constitutes those things. You know, but if you have someone who maybe they're, you know, I say I don't know what constitutes those things, and here I'm about to give you an example, but fraudulent track writing, probably can't discriminate on that unless it's one of those felonies. So be really careful, because if you see like, oh my gosh, this person gets picked up by the cop every weekend, you know, look at this, you know, rap sheet. But if they've never been convicted of any of those things, that's not one of the reasons that you can discriminate against them. So, you know, you can still look at people's credit. You can still look at their income coming in. And if you have a threshold of the amount that they need to make in order to qualify for the apartment or the rental or something like that, then you could do it based on that. But you have to be across the board. So you can't, you know, up the ante just because you see that this person's been arrested a number of times. Okay, well, now we're going to make it that you have to make this kind of money. You can't do that. It's got to be, these are our rules. This is what we do. I have one client, and he has on his website, because there's testers that go out and they'll call and they'll want to make sure that people, you know, that these property management companies are doing the right thing, or the landlords are doing the right thing. So they'll pose as different people. You know, just saying, hey, I want to apply, like, but I you know, I just got out of jail or something. And then, you know, you got to watch what you say because you could get in trouble. So what one of my other clients is doing is he's just saying, hey, look, if you go to my website, this is what the criteria of what will, you know, we can pull pull your criminal history, but maybe you don't even want to apply if this is what, if you have any criminal history within these parameters. If you take the Louisville Metro, and I can give you exactly what it is, and you put it on your website, we have, the fair housing logo. We don't discriminate against, national origin, sex, familial status, and any of these things in the Louisville Metro area. That would be a good thing, because they may know, what their criminal background is, and maybe they don't want to waste the money to put the application in if they know that they're not going to be approved. There's also, you cannot discriminate against people who are homeless. So if they are, if you take an application and the address that they have is for the St. John Center, or, Wayside or something like that, or their parents' or siblings' address, because they say, I don't currently have an address, you can't discriminate based on that. In the past, you've been able to say, oh, okay, well, maybe that's an indication that they can't make their payments if they don't have anywhere to stay. You can't do that. You can say, all right, let's look at your credit. And if you have a bunch of evictions, then this is this. You also might want to say that you have, when you're dealing with credit and stuff like that, that it's not just one thing, it's a totality of the circumstances, and that is a legal term. So you look at everything all together. Maybe they've never had an eviction, but they have 15 things in collections. Maybe but something's different, and you want to make it kind of broad on that level, so it's the same standard, but at the same time you get a little bit of leeway. Nobody's credit history is going to look exactly the same. It's not. So if it's a clean credit history, they have some arrests, they make the same amount of money, you can't discriminate. You're going to have to let them rent. And just, be careful when you get phone calls. What I would do is just say, please refer to my website, and you can see, who we, that we abide by all of the rules. I don't have them memorized, because it's going to be, everyone's going to have to look at this stuff a little bit more carefully, because what you used to be able to do, you can't do anymore, at least in the Louisville Metro. So that is the Louisville Metro aspect of it. Does anybody have, let's see. Okay, so exactly what I'm talking about with those testers. Steve Hoffman said, I recently had the Louisville Human Relations Commission call and pretend to be a family of 5 and applied to a 2-bedroom apartment he had for rent. I've always been told that it's okay to say 2 people per bedroom, so I told them that it exceeded the capacity, and they did file a complaint against him. He was told by an attorney that you can't do it anymore, and it's based on the apartment size. They requested a layout with the square footage of the apartment, which they supplied, and he's waiting for their response. So that's one of those things where you can say that but maybe they can put somebody, in the family room. I would imagine you can't have more than 2 people in a pull-out bed, and then you get the ages things, because, okay, well, do you have, it gets really, really tricky. So use your best judgment. I think that if you have out there that you are trying to fall within the standards, or if you say, hey, this is what it is, no, you can't discriminate against ages, but maybe a baby in a bassinet is different than a 20-year-old son or something like that. But I don't think you can do that. So you have to look at the sizes. I'd be interested, Steve, to see what they come back and tell you. So please let me know, and we can see what they we can update everybody of that. So the question is, on Section 8, what if you just don't want to deal with the Louisville city government? It seems like you're forcing you to do that. So I do believe that the reason that they put into the law that you can't discriminate against the source of income, I don't think a lot of people are discriminating against people who are getting Social Security. I mean, it's a guaranteed money. Why wouldn't you be? I think what it is the way to get to open the door to the Section 8 conversation, which here we are, we're having it. I think that that's where it's going, but I do think it's really going to be hard to say that you have to change your house and do all of these accommodations. I think that's where the crux is. I don't know that you can say you just don't want to deal with a government agency. Because then again, you're kind of saying maybe you don't want to deal with a government agency that has to do with their source of income. And it would fall within that of discriminating based on the source of income. So I would be weary of saying that. But I do think that you could say, and again, I don't know of any litigation that says anything alternate to this, so this is just my opinion, but I do think you could say about the accommodations and the changes to the apartment or the house in order to make it compliant. Not necessarily Section 8 compliant, but just that you're not going to make, all of these changes. And again, that you might lose a good tenant because you have that on your website and they're like, well, geez, this guy's not gonna, or this girl's not gonna, what if something big goes wrong and there's water? Are they gonna deny me for that? So I think that conversation, about like, hey, this is, it's so tricky because you can't tell them like, this is why we're doing it. But at the same time, I have a good reputation and I promise it will make repairs when they're needed. But then again, you may also be putting, maybe you're giving people, the heads up that a lot of frivolous things, we're not going to do it. I mean, I've had landlords that have been called to change a light bulb to a fully to something that was not out of reach. So, then at least that starts a conversation that, hey, these are the types of things we're going to do, but you want to change a light bulb, you're going to have to change the light bulb yourself. That kind of thing. So, I also wanted to talk about love letters. So if you are in the industry and you are listing a house, I mean, my goodness, everyone knows it is a seller's market, and sellers can basically ask for almost anything that they want. Delayed possession, no repairs, waiver of appraisals, the reverse contingencies, all of these things. You cannot, however, say that you want, I mean, you can, but you shouldn't, say that you want a letter telling the backstory about every offer that's been put out there so that you can really know these families or people. Family right there is a big red flag, that you can know about the people and you can make it based on that. Okay, right there, you're saying that you're going to discriminate against somebody's familial status or their age. I mean, right there, you're saying it. So if you get the same offer and one of them is a gay couple and the other one is a straight couple, and you go with straight couple, that's not good. You got this long letter about, different things. Or we're brand new family and we're starting out and we really want to be somewhere where we can, watch our children grow. And the woman who's, the couple that's selling the house has lived there for 40 years and they've watched their children grow and they're thinking about the Christmases that they've had or Hanukkahs or whatever. And they're like, oh, I would just love to see a family. I'd love to see a young couple move in. That's discriminatory. So the problem is that it, there's a lot of problems with that, but proving that it was discriminatory may be an uphill climb. Getting the information on that during discovery of a lawsuit, you would be entitled to see that. But most people aren't going to go to those lengths. But if they feel like they've been discriminated against, maybe they will. So I would just really steer clear of those love letters as a listing agent. If somebody sends one to you, it's like, oh, I just want your clients to know all about my clients, and they're wonderful people, and maybe they're they're former military, and they see like a Semper Fi flag or something. They're like, oh, well, you could say that you're discriminating one way or another in that aspect. So you, gosh, in Louisville, maybe U of L versus UK, but those aren't protected classes at this point. I guess you could say you're discriminating against one of those fan bases, but they have not been protected yet. But I will say that the more information you have to be able to make a claim of discrimination, the more likely it's going to happen. If you are asked to provide a letter, if you provide the letter, it's really it's the seller that's going to be discriminating. But I mean, I just think, I wish that I wish people wouldn't require that as part of their offer. If you receive an offer and it has that on there, what I would say is tell your client, like, look, there's another section to this, but it may open the door to some discriminatory stuff. So probably be better if you don't even read it. But I got to present it to you because I have a duty to present everything to you. But there you go. And they might be like, well, I'm going to read it. I'll take my chances. Let's roll the dice. But they may also say, okay, then let's look at it based on the numbers. That's what it should be based on. And again, with the veterans and the VA loans, I do know that, they get a really bad rap. If you don't know about VA Rep, which is the Veterans Association of Real Estate Professionals, it's a really good group. And we talk a lot about, do a lot of education to different brokerages. And GLAR is actually having a class, 8 hours. You can learn all about it, but please learn about that so that if, somebody who is qualified and can, and there wouldn't be an issue, that you don't discriminate against those types of loans. Again, you can't discriminate against the veteran, but as a sidebar, it is really important that everybody understands those because I think they get a really bad rap. And if your brokerage wants us to come and do a class at there, we would be really happy to do just a little lunch and learn. All right, so, okay, and then okay, so Will Fisher just put in the chat that there's a training for realtors that uses the power of storytelling to help identify discriminatory practices. So that's really good. You guys should be going to those things because I think that there's a lot of times where people don't realize what they're doing may be discriminatory. On the back of this sheet that I looked at originally, there were some case law, and I'm just going to tell you a couple of them that jumped out at me. So in order to file a lawsuit, you have to have standing. And what that means is that you actually have the right to bring an action against someone. Okay. So you could say that as a tenant, I have standing to sue the landlord. Clearly you do. Okay. There's a contract there. But do your guests have the ability to sue the landlord? It actually was determined that in Pennsylvania that they did. So under this one, the court allowed a property guest to sue where the rental, she went and visited a friend who was renting a property, and the woman's children were Black, and the landlord said that they weren't allowed to be there. Okay, so they got to sue and they won because it was discriminatory. So guests do have standing to sue in discriminations. Let's see, there was also one where they had testers go out, and there were 3 tests. The people of different ethnicities were treated differently. So, just make sure that your demeanor is the same, that everything's the same. Because if it's on a recorded line and you're like, well, blah, blah, blah. Well, I said the same thing. Maybe that could be discriminatory. Let's see. And I talked about the apartment with the Korean. That was actually one of the cases. And let's see. Okay, there was one that this is interesting, I think. So a Texas federal court ruled that Home Builders Trade Association had standing to bring a lawsuit over a city's ordinance that violated FHA. And what it was is that the city ordinance required new homes to have a garage. And the garage increased the sales price from $100,000 to $138,000. And they sued, saying that it increased the price of entry into housing. And they filed a motion. They said that they didn't have standing because the trade association didn't have standing to bring this lawsuit before the court. And then they said, yeah, they did. So GLAR could bring forth an action. You could have the Home Builders Association bring forth an action. And let's say they went on. So basically the lawsuit was about, the question here was really about standing, but they also said that the interest in the associations seeks to protect all of the people within the association. So it didn't really make a decisive, whether or not that is something that you can do, where you can require garages, but it's an interesting argument to be made. Let's see. All right, so this, if you guys look in the chat, and I'll actually, what I'm going to do right now is I'm going to copy this, and I will also put this on the Facebook page so that if somebody wants to do this Fair Haven, and if you go on your GLAR email, there's the bottom of one of them, and I think it's the first one of September, has tons of resources. NAR has tons of resources. So please make sure that you're reading this stuff, make sure that you're staying abreast of what's going on, because I think what is happening with a lot of this stuff is that people are doing things and they don't understand that they're violating. I would venture to say that most people in Louisville, with the crimes, and most people think that they can say, oh, you have a criminal conviction, I'm not going to do it. You can't do that anymore. So just be aware of that. Also be aware of, all of the different things. And if one of your clients is like, hey, I've read something, let's get a letter from everybody and let's choose based on emotion. Choose based on numbers, okay? Which offer you're going to take. Come to the VA rep stuff, hear about VA loans. And what I'm going to do, anybody who is on this, if you're on the Zoom webinar right now, I will email you the link to the document that I read, and then to the Fair Haven website that you can access a lot of videos and different things like that. Does anybody else have any questions? I don't see any. All right, if you do, as always, just give me a call. 553-2957 is my cell. Colleen at English Law Group, and I'll put that all in the meeting. But I'm glad you guys are on here, and happy Fair Housing Month. All right, thanks, guys.